Good morning. Hello, everyone. It's me, Lauren Cadillac, aka OG Cadillac, aka Mother of the Decade, aka your favorite internet lawyer. I'm trying to think of another aka. Can't think of any other AKAs. Good morning. Morning, Blue Nettie. Good morning. Good morning, everyone. Or Chairman Nettie, sorry. Oof. It is absolutely 100% allergy season in Dallas. So, pardon my leaky eyeballs, pardon my leaky nose. It is full-blown springtime here, okay? And I have Kleenex. I'm not crying. I'm not sad. I'm just in Texas. Speaking of Texas, guys, I'm not sure if I've told you yet, but my newest obsession is a certain artist called Big X Da Plug. If y'all have not heard Big X Da Plug, you need to. He is a Dallas native. Last week, we talked about Yella Beezy and Mo 3, right? And I showed y'all a map of Dallas, but I'm going to do it again. So, I've been pretty obsessed with Big X Da Plug because he has this great song. I'm from Texas. All right. So let's go over Dallas. We'll talk about Yella Beezy first, okay? So if you're not listening to Big X Da Plug, you need to be. All right. So here we go. All right. This is Dallas. All right. The great city of Dallas. This border here, I-20, I think this is the most southern border, so I think that's good there. And then 635, it's not the most northern, but it's the most northern that we think about when we think about Dallas, okay? So there's like a big hoop-de-hoop. Oh yeah, 635 links up which way? I was wondering where the rest of the loop 635 was. I guess it's 20. Okay. It's not a true loop. They connected 161, but obviously it is not a true loop. In Texas cities, they love loops. Okay, let me show you a map of San Antonio. All right. Love loops in this state, all right? So look, this is San Antonio. Note loop 1604, loops around the whole city. Then you have loop 410, which used to loop around the outside border of the city, and the city expanded so much, now 1604 is the outside loop. All right, familiar? They love loops here. They call them loop. They call this loop, L-O-O-P, 1604. They call this one loop, L-O-O-P, 635, all right? So this is how we build our towns, all right? So, oh, Lord. Guys, oof. Sorry, falling apart over here. All right, so this is Dallas. Up here, in Vickery Meadow, this northern area up here, super hood. This is where Mo 3 is from. This is Mo 3's hood. Up 635 Forest. This is kind of a super hood area, okay? Then you have Oak Cliff. Now, they call this Cedar Crest, which is the neighborhood name, certainly, but the way I view Oak Cliff is that Oak Cliff goes to 45. So when I think about Oak Cliff, I think about 30 being the northern border, 45 being like, was that the eastern or western border? And then 12 being the other border. So I see Oak Cliff as starting here, going here, coming down here, not down here, sorry, to 12, and then up and around. All right, 12 is also a loop, loop 12. All right, so this to me is Oak Cliff. This is where Yella Beezy's from, okay? I think he's from East Oak Cliff, but I'm not 100% sure. All right, so West Oak Cliff. Dallas is a very segregated town, so this part of Oak Cliff, well, hold on. This part is really white. This part is Hispanic. This part is black. And this part down here is kind of a mix, okay? I didn't build the city. I didn't make the rules. Apparently in the 80s, there were a bunch of like pastors that came together with like the leaders of the city, and they ensured segregation. They wanted it, and so they made sure that it remained segregated. Okay, so Yella Beezy's from probably somewhere over here. Then we have Pleasant Grove, which is like, where is Pleasant Grove? I think it's, oh, right here, where it says Pleasant Grove. Okay, so you go out east of Oak Cliff. I think this is east, never east. Yeah, east of Oak Cliff, Pleasant Grove, Balch Springs. Hood as fuck. This is Hispanic and Black mainly. In Balch Springs, there was a shooting where an officer killed a 15-year-old boy who was, there was like a house party and all the kids were fleeing, and for some reason the cop shot at this car. I don't remember why, but that cop's in jail, so we did put that cop in jail. But PG, super hood, still super hood. Oak Cliff, still super hood. This area up here where Mo3 is from, still super hood. I say still because there's a lot of gentrification going on. Like this area where I told you it's mainly white now has been fully gentrified. That's why it's mainly white people now. Okay, so Big X the Plug's over here. Yella Beezy's over here. Mo3's over here. Okay. When you're young, you're not going to actually know about these other people existing, right? You're not traveling around the town. You don't really, like when you're young, when you're Big X and you're growing up over here, this is the world you know. But then you start to expand, get outside of that world, and you start competing in the Dallas music industry. All right, now I'm going to zoom in here, and I am going to find the Bank of America building. Where is the Bank of America? There's Zang, Beckley. That's Clarendon, so it's too far south. Okay, the Bank of America building is somewhere, Jefferson. Hold on. Okay, here's the zoo. So the Bank of America building is like right over here, I think. Actually, let me just ask. Oh, where'd it go? Where did it go? Where is it? Okay, here it is. All right. All right. This is the Bank of America building, all right? It's a 9-story building. It's like the only tall building in Oak Cliff. Now you can see the Bank of America building, it actually has some really good views. It has a great view looking south on 35 and out towards DeSoto as you drive to like Boston. It has a gorgeous view of downtown up and over here. It's got a good view over here of Oak Cliff, etc. All right, so I want you to think about this map, where this building is, and now let's watch the video that the DPD released yesterday of Mo3 being gunned down. All right, here we go.
This video is taken from a Kroger 18-wheeler, and this is heading north I-35 into downtown Dallas
Okay, so they're heading north on 35 into downtown Dallas. Hold on, let me go back to our map. So they're driving this way. Can you see my arrow? They're going, let's exit out of this. Hold on. They're driving this way. So they're driving from Oak Cliff north towards where Mo3 is originally from. All right, so they're driving up north. They're driving north on 35. This is like 11 something a.m. in the middle of the day. It's COVID, so you can see there's not much traffic. Oh, God, I miss COVID traffic, Lord. All right, here we go.
November 11, 2020.
Okay, right here, this building, that is the Bank of America building I just showed you. All right, so that building is right here. Wait, was it? No, it's right here. So, hold on, let's go back here. This building, let me orient you. This building here that is just to the left of this white box truck. All right, right here. the building right above this white truck. All right? That building is right here. So they are somewhere on this stretch of highway because they don't appear to be making a curve. At the time this video happened, 35 didn't curve like this. They were doing a bunch of construction and they were redirecting 35 because they're building a park, like a deck park for us down in the south. Okay, so here we go. That's the building. Now you're oriented. Now you know where we are. I lived in this neighborhood. Belen still lives in this neighborhood. She grew up in this neighborhood. I lived in this neighborhood for decades, y'all. When this happened, we went back and we looked at our calendar. We were in our office, which at the time, hold on. Our office was, let me zoom out, right 67 in Hampton. It was right here. This was our office. So let me zoom out. This was our office. This is the Bank of America lobby. This is where the shooting happened. And we were in our office taking meetings that day. When it happened, we were in a meeting. Okay. All right. So this is like very nearby. Hey, Nene, welcome. All right, here we go. Okay. We're getting closer to the Bank of America building, so we're moving north up 35. This is what I want you to watch. These cars just came from what is our left, side by side. So hold on, and actually let me, for the first time ever, I'm gonna slow it down. I always do it faster. We're gonna slow it down. All right, here we go. Getting closer to Bank of America building, closer to the zoo. Note the construction. I told you they were rebuilding. Okay. Now the two cars come into our view. Notice this car is like what? Maybe 1-2 wheel ahead. They're up next to each other. They're driving in their lanes. This guy kind of swerves. Gets up sort of ahead of the gold sedan. Now the gold sedan is stuck behind this car, and now you have this car. Black car is still up here. Bank of America building getting closer. View of downtown Dallas over here. This is, now the black car is one car length ahead. Okay, stop. So the black car is one car length ahead. The prosecutor is going to point out something that doesn't really mean anything to us. So this is Mo 3's sedan. He's driving a gold Honda Accord. This is a black Charger Camaro something, I don't know. It was in the middle lane. Now mind you, they came up together. This guy got ahead, but they stayed in parallel lanes. Now he's coming into the left lane, and Mo 3 starts to go to the right. Oh, could they pause it? Okay.
19 seconds. You see a gold.
Okay, so the prosecutor's telling the judge right now, this is the gold sedan. This is, keep your eye on these cars. These are the only cars that matter.
Sedan will be the vehicle carrying the victim, and the black sedan is the vehicle driven by Q1Y, who is then the shooter.
Don't forget it's slowed down. This guy doesn't actually talk this slow. Okay, so he Shooter moves into the lane in front of the box truck. Mo 3 stays here on the left. We're getting closer to that Bank of America building. We see downtown on the right. Mo 3 stuck behind this car. The black car comes into Mo 3's lane. Mo 3 almost hits the box truck. Box truck moves over. Mo 3 gets over. Now he's in the lane. And the 18-wheeler is behind him. This car, this guy, whoever's in this truck, I should tell you, this is like, what he's about to do is the most Texan shit ever. We have this thing called a Texas exit. If there's too much traffic, we'll just like go off on the dirt and exit the highway. We got our own style here, y'all. So this truck, in true Texas style, he's like, I don't know why these cars are stopped. I don't care. Let me just, hold on. Yep, I'm going to go around it. And action. Now, Mo 3 is getting out of his car while this guy is trying to get around the other stopped car. Mind you, here is the Bank of America building. So hold on, let's go back. Here is the Bank of America building. In order for us to see it that closely, they've got to be somewhere like right here. Oh yeah, they said it was near Clarendon. I had an office location right here at one point. Like, this is so close to home, y'all. Okay. Actually, my office is like, you could see it over here. So he gets out of his car. He didn't walk that slowly. We have it on slow motion. These cars go around. He has his phone, obviously, in his right hand. I think he's going into his car to get a gun. Now, this guy comes out, does not care about any of the cars on the highway, starts shooting, comes to this side, nah, turns and goes to this side, still shooting. And that's it. So they have found that it is very clear, based on this video, that the black car, when they're driving together in the beginning of this video.
35 heading northbound.
Okay, when they're driving together at the beginning of this video, the black car had to have brandished a weapon because there's no other explanation. Here they are coming up to it. They're driving side by side. The guns have got to be shown because there's no other explanation for Mo 3 to jump out of his car and go around. Also, why do you have a gun in your car that you got to jump out and go around to? This is Texas. We don't even, like, we have concealed carry, like, well, we have open carry. Like, you could take your gun to Chipotle here, you know, like, it doesn't make sense that you would have to park your car, go around it to get the gun. I don't know. But it's very clear to me through the video that when they were driving together up 35, the gunman was pointing his gun at Mo 3. So a bystander in a car got shot. I don't know if that happened while they were driving or if that happened when the dude got out of the car and started shooting. Okay, so that is my Yella Beezy update. Obviously, that's in Dallas. So obviously, I'm going to the damn trial. And we'll do a meet and greet here in Dallas, right? And we'll watch that trial intently together. My understanding is Yella Beezy paid $2 million for that hit. And that's crazy to me because I've heard of people paying like $5,000. $2 million seems really pricey. For $2 million, I want like a movie style. Like I want like the TV show The Jackal. Okay, I want the Jackal. For $2 million, I want the Jackal to show up. It's gonna be quiet. It's not gonna be broad daylight on a work day on a Wednesday at like 11 something a.m. Like, fuck out of here. Good morning, Simply Erica. Good to see you. Okay, so speaking of meet and greets, I am going to be in New York City May 5th and 6th for the first 2 days of the Diddy trial. All right? I want to do a meet and greet there, but the problem is I know nothing. Nothing, not one single thing about New York City. So, where should we meet on the 5th or 6th? I'm thinking we should meet on the 6th because, well, at least here in Texas, Cinco de Mayo is a very important drinking holiday. So maybe we should meet the 6th. All right, so if y'all have any suggestions about where we can meet in NYC, I'm staying a 7-minute walk from the courthouse. So hit me up, let me know, put it in the comments, please. Okay, since I last saw you last week, there has been more news. We have seen more RICO charges. This is exciting. Not really. You guys know I do not like RICO. I only like RICO for the federal government. I do not think RICO should be at a state level. I think it's bullshit. This I believe to be federal though. So let's check it out.
Good morning. I'm Joe McNally, the acting United States Attorney in Los Angeles. Today,
Okay, so yes, this is federal. He is a U.S. attorney out of Los Angeles.
we're here to announce federal criminal charges against Eugene Henley Jr., a career criminal known as Big U, who used his contacts and leadership role in the Crips criminal street gang, the entertainment industry, and a youth charity to further his own criminal enterprise, an enterprise engaged in murder, extortion, robbery, human trafficking, COVID fraud, and other felonies. Mr. Henley...
COVID fraud, guys. Okay, so Eugene Henley, aka Big U, he has a bunch of AKAs. I think this guy will get into it. Is the leader of the Rolling 60s Crips, and he has. My understanding is he was kind of like born into the Rolling 60 family. I think like his uncle or his dad or both were in that particular organization, and so he's kind of like, you know, born into it. My understanding is he runs the thing like he's John Gotti. Like, there's a whole thing about checking in and paying tax, and I mean, it's straight out of The Godfather. So let's watch some more here.
and several other individuals linked to him and his criminal enterprise were charged in a criminal complaint with federal racketeering conspiracy. Mr. Henley is a fugitive, and he is currently wanted by federal law enforcement. Other individuals linked to his criminal enterprise were arrested today, approximately 10 defendants who are charged in various indictments. Again, Mr. Henley is a fugitive. 4 defendants are in state custody and will be transferred into federal custody, and we are still seeking Mr. Henley and another fugitive. The Department of Justice's top priority is eliminating violent crime caused by criminal street gangs and organized crime. These organizations cause a tremendous amount of harm in our communities. And today's arrests are part of our office's efforts, FBI, IRS, LAPD, the team you see up here, to make our communities safer and rid our streets of these criminal street gangs, including ones operated by violent felons like Mr. Henley, who are posing as savvy businessmen and community leaders, but in the end are violent criminals. The affidavit filed with the criminal complaint alleges that Mr. Henley operated Big U Enterprises, a mafia-like organization that utilized Mr. Henley's stature and long-standing association with the Crips criminal street gang and other gangs here in Los Angeles to intimidate businesses and individuals in our communities. I want to stress that the allegations here in the complaint are allegations only, and the defendants are presumed innocent until proven otherwise. Let me talk a little bit about Mr. Henley and the street gang here. As I said, Mr. Henley is...
I'm really glad he said that. You know, I don't know if you've noticed, but when we're watching these state prosecutors, they tend to not outline your constitutional right. They kind of tend to, oh, these people are guilty, you know, as it is. They really don't emphasize that, you know, you are innocent until our government proves beyond a reasonable doubt that you are not, right? And so the fact he said that, I like that. And I think that's because he's a Fed.
Is a widely known leader within the Rollin 60s. He rose to prominence in that gang decades ago, and he has since been a fixture on the internet, talk shows, and podcasts. All things that law enforcement have looked at closely as part of this investigation.
Did you guys ever see that movie American Gangster? Remember the movie American Gangster? It had Denzel Washington in it. That movie's based off a true story of someone who basically ran the streets in the 60s and early 70s, Frank something or other. And back then, we didn't have camera phones, we didn't have stupid ass social media, we didn't have anything like that. But the way that Frank got busted is he went to like I think it was an Ali fight, I don't know, he went to some boxing match, a pretty popular, well-publicized boxing match, and he wore $100,000 floor-length chinchilla fur coat. Frank Locust. Thank you, Nene. So he wore this chinchilla fur coat, and in the movie, he did so at the insistence of his partner, girlfriend, I don't remember what she was, wife, I don't know. And that is how he got caught. The government saw this man in this coat that they knew cost a shit ton of money. And they're like, oh, there's our guy. This man had laid low for like a decade. And he wore this fucking fur coat. And he gets busted, right? Going on a podcast, going on a YouTube show is the 2025 version of wearing the chinchilla coat. Going out and self-snitching publicly, documented, recorded, is the equivalent of Frank's fur coat. Full stop. Full stop. There's no better way to self-snitch than to go and say it, okay? Frank just wore it. He self-snitched through his attire. This guy, Eugene, Big U, is freaking going out there just giving it away. Let us continue.
He has maintained the image of an entertainment industry entrepreneur, running a music label, and of somebody who gives back to the community here in Los Angeles, funding a South LA-based charity, developing options, which purports to help at-youth risk escape gang life and escape the perils of gangs in high-crime areas.
He said out-youth risk. He meant at-risk youth.
The facts alleged in the complaint paint a very different picture. It is one of a murderer, a thief, a liar, and a cheat, and the criminals that enabled him. For example, Mr. Henley engaged in a murder of a musician signed to his label in 2021 and dumped the victim's body in Las Vegas off of the I-15 freeway. He then attempted to evade and obstruct the investigation into the murder, including ordering witnesses not to speak with law enforcement. Henley's criminal enterprise also engaged in other crimes, including transporting prostitutes across state lines, extorting strip clubs, marijuana dispensaries, and other businesses, and fraudulently applying for COVID loans in the form of a business relief loan. On that application, Mr. Henley falsely stated that his music label, Unique Music, operated at a $200,000 profit in 2019 and was entitled to government assistance, despite the reality that the company had operated at a loss and was ineligible for such relief. Finally, Mr. Henley is accused of embezzling donations made by celebrities, professional athletes, and businesses to his charity, Developing Options, which, as I said, purports to give South LA at-risk youth alternatives to gang violence, drugs, and other criminal activity. Henley used this charity as a front. He used it to conceal his fraudulent activities, his criminal enterprises activities, and evade detection from law enforcement. If convicted on the racketeering conspiracy, he and his co-conspirators face approximately a 20-year federal prison sentence. I want to thank our federal law enforcement partners, our state law enforcement partners who brought about the result here today. The Los Angeles Metropolitan Gang Task Force from the FBI, it's comprised of FBI agents, LAPD officers, IRS Criminal Investigation, U.S. Department of Justice Inspector General's Office, Los Angeles Police Department, the North Las Vegas Police Department. This case is a great example of state and federal law enforcement working together to address harm from a criminal enterprise. I also want to thank our prosecutors, Assistant U.S. Attorneys Kevin Butler and Jen McCabe, for their diligence and dogged determination in this case. With that, I'll turn it over to our next speaker, FBI Special Agent in Charge, Ted Dox.
Thank you, Joe. Absolutely. My name is Ted Dox, Special Agent in Charge of FBI Los Angeles' Criminal Division. These operations are truly a team effort, and I would like to recognize those partnerships. If not for their commitment, dedication, and follow-through, we would not be here today. First, I'd like to thank LAPD, IRS Criminal Investigations, and the U.S. Attorney's Office for working collaboratively for the past 4 years, in this case with FBI Los Angeles Metropolitan Task Force on violent gangs. I'd also like to thank the U.S. Marshal Service for their assistance today, and many departments in California, Arizona, Nevada, and the North Las Vegas Police Department. Now, this morning, hundreds of agents and officers, including multiple SWAT teams, executed multiple arrest warrants for many of the 19 defendants charged in this case. Search warrants were executed at 6 locations. Those searches continue to be underway. 4 of the 19 defendants were already in custody, and 10 defendants were taken into custody in the last 24 hours. And while we're still seeking the whereabouts of 5 individuals, 3 of whom we believe we...
Okay, so, did you hear him thank the IRS Do you ever think that IRS? The way that, I don't remember which one it was. One of the mobsters of the 40s or 50s or something, he actually, the way they got him was not on any of his actual crimes. I think this was before RICO. They got him on tax fraud. Because in the USA, you have to pay taxes on illegal income. Okay? So there's a big debate out there about is declaring illegal income on your IRS taxes a violation of your Fifth Amendment right to remain silent, right? Because if you tell the IRS, hey, here's this income that I made illegally, you are basically giving yourself up for a crime, right? It was made illegally. You're admitting to doing something illegal that gave you money. And that is a violation of the Constitution, right? So it hasn't been adjudicated, to the best of my knowledge, about which how do you do it? But you have to claim your illegal income. So when you have someone like this, like who's running basically a mafia, the way you can get them is when they don't report that income. And that's why the IRS helped here.
They are Eugene Henley Jr., also known as Big U, and Brian Mejia. We will provide their photographs to the media following this announcement. Anyone with information as to their whereabouts should not take action on their own, but contact the FBI. You can reach us by calling 1-800-CALL-FBI.
Do not take action on your own. These people are cold-blooded killers. My understanding is that Big U had some artist on his label, and that artist made some flippant song talking about he who has the money and he's gonna shoot me in the face with a .35 revolver, and then a few days later the kid died by being shot, or sorry, a .38 revolver, by being shot in the face by a .38 revolver. One of Big U's nicknames, I think, is like Anyone Killer. So yeah. If they have not gotten him, if he's still on the loose, he's probably headed to Vietnam. Why, you ask? Well, Vietnam does not have extradition. There's no extradition agreement between the country of Vietnam and the country of the United States. There are several countries that have no extradition agreements. Actually, let's look those up. One of them I looked up, it's like a country of like 13,000 people, so they don't want nobody. With no extradition treaty. Okay. So our countries with no extradition. We got Montenegro, and I think that was the one that had like the really small population. They don't let anyone in. Or maybe it was Moldova. I don't know. One of these. Anyhow, you got China, Iran. We're not going to run there to either of those places, especially if you're a woman. Okay. UAE. Oh, that's nice. You might go to... If I'm Big U, I might go to UAE. Not going to lie. Morocco, Moldova, Vietnam, Brunei. Oh, maybe it was Brunei. Yeah, because they're like a really wealthy country. They don't want our people. Cuba. You're not going to go to Cuba. Indonesia, Laos, Qatar, Russia. Who went to Russia? Hold on, what was his name? Snowden. Edward Snowden is in Russia. Solomon Islands, Uganda, Ethiopia. I didn't know that. I'm going to go to Ethiopia in January. The Maldives, that's a very beautiful place to go for a vacation. North Korea. Good luck there. Somalia, Belarus, Vatican City, of course. But they're not going to take you in. All right, so the reason I'm talking about where Big U might flee is because I'm going to segue into Donna Adelson. We've never talked about this case before. All right, so this is our first time talking about this case. All I know about this case is I saw the news where they picked up Donna Adelson at the airport because she was flying to Vietnam. Her son is serving a prison sentence for hiring people to take the life of her daughter's ex-husband. All right, so her daughter is an attorney. Her daughter's ex-husband is a law professor. They lived in some small town in North Florida. Donna, who's a very controlling mother, very highly helicopter mom, is in South Florida, very overly involved in her children's lives. And Donna's sons are in South Florida as well. One of the sons pays these two, oh God, what were they? They were either Latin Kings or MS-13. I don't remember. There's some Hispanic gang members to take the life of the ex-husband because the Donna Adelson's daughter was wanting to move with her kids south to be closer to her mother, but the courts often prevent that. You can't just take your kids and run away with them, right? So you have to have you have to have a job lined up. You have to have a bunch of evidence of why you need to be allowed to move, and you got to get the court's permission. So it is easier to just take the life of someone. All right, on her divorce day, Wendy is Donna's daughter, the lawyer. Wendy's brother gave her a television and made a joke that it was cheaper than hiring a hitman. And he made that joke to several people, which, you know, it is in poor taste, but I do think, you know, a brother, I could see if there were a situation where my daughter had a husband and he was like kind of a shithead, and then they got divorced. You know, my son didn't like him, right? Because he was a shithead. He didn't like the way the man treated, you know, my son's sister. I could see him making some joke like, oh, here are a bunch of TVs cheaper than having him killed, right? Like, the problem with the joke is that the dude ended up getting killed. That's the problem. It's like one of those truth jokes, right? Like, oh, it's a joke, but actually I'm telling you reality. So the son is in jail, and Donna knew that she could and would be investigated. As I understand it, she was the bookkeeper of her son's business, and she cut the check to the people who did the job. That's how I understand it. All right. She is going to trial, I think, next week. I think her trial starts next week or the week after. Her trial starts soon. Let's put it that way.
I think it was last week before, Your Honor, issued the order concerning the prior investigator. When we were first before the court in December, we were told that the defense would have the benefit of what already occurred. I certainly understand the conflict issues, but our client is being punished in prejudice in her ability to defend herself, not based on her actions, but on the actions of the former attorneys. It's our understanding that one of the things that the investigator did was travel down to South Florida, take pictures, identify times of travel. We don't have those materials. We're asking for an exception to the court's order to get those materials, not his reports that he generated through interviews. Indicated that we would address it here this morning. The purpose of submitting that is so that there is complete clarity on the court's ruling, that there's not an issue. We are not trying to get into a situation where we're having to seek a mistrial.
As to that, I reviewed the original order and also what was proposed. They didn't exactly coincide. Is there something in particular that you believe needs to be clarified based from the original order?
I don't think that there is. I think that there's a difference in opinion as to what the court's order meant.
That happens sometimes. Sometimes the court will issue an order and everyone will be like, And sometimes you'll read it one way and then, like, I don't know. So here they're just trying to clarify.
I reviewed the transcript on that as well, and I believe as it went to the state presenting any evidence of motive, or specifically that Mrs. Adelson was somehow involved with the offer of money relating to the, I believe, relocation of the children that evidence would be permitted as far as any general evidence concerning her money, such as what her net worth was on a particular date. That was not going to be presented. But again, as it relates to presenting evidence on motive, that would be presented. What is unclear about this?
I think that clears up the.
Ms. Dugan, do you need to be heard on this point?
We've already filed 2 additional motions in limine.
Okay.
Unless either party has anything further to address, we'll be in recess.
See what else goes on. So they're doing motions in limine, which are pre-trial motions.
And at 9 o'clock, that will be the next date in which the matter will be addressed. So pre-trial is already preset by order for 5/16 at 9 o'clock.
Okay.
That will be the next date in which the matter will be addressed outside of any other motions.
So May 16th is the next pre-trial hearing.
To address, and we'll be in recess for this case.
Thank you, Your Honor.
All right,
As
so
conclusion of the hearing, have a good afternoon, everyone.
her case is coming up, and it's going to be very interesting. And I'm looking forward to that one. We're going to follow that. All right, so next I'm going to quickly touch Karen Reed because her trial starts on April 1st, Tuesday. Also, Lori Daybell, the Idaho mom who thought her children were possessed by evil spirits, who took the life of those kids. She is being tried for the taking of the life of her husband in Arizona. She is representing herself, and her trial starts on Monday. That one is going to be so fun. So that's what I'm going to be watching next week while I work, because oh my goodness, the pro ses are so fun. All right, Karen Reed's trial also starts April 1st. Here's the judge. They're talking about they had been talking about voir diring of the jurors, and this is a what to know ahead of Karen's retrial. So this was the NBC 10, and we're going to watch this. Thank you, NBC 10, for sharing this fair use video.
July 2024, you can your pick drop inside the Dedham, Massachusetts courtroom. After nearly 5 days of deliberating, the jury in the Karen Reed murder trial could not reach a unanimous verdict. Outside the courthouse, cheers erupted from dozens of supporters wearing pink who had been standing along the sidewalk for weeks.
We are accepting the hung jury.
If this is retried, will you be here?
I will 100% be here.
The number of people in blue supporting victim John O'Keefe and his family also grew during the first trial.
Most normal people don't show up and tailgate at a murder trial, and we're here to support the O'Keefes. They have been harassed relentlessly.
The case has garnered national attention.
It's smoke and mirrors, and it's going through my private life and trying to contrive a motive that was never there.
They failed miserably, and they'll continue to fail. No matter how long it takes, no matter how long they keep trying, we will not stop fighting.
Karen Reed and her defense team spoke on the steps of the courthouse moments after the judge declared a mistrial. Minutes later, the district attorney's office decided to retry the Bristol County woman for the death of her Boston police officer boyfriend, John O'Keefe.
Okay, I'll go back to the video in a minute, but we talked about Karen Reed, I think last week, maybe it was the week before. I watched the HBO documentary, and I suggested you guys do that. After watching the documentary, I myself was like, I don't know what happened. And I just don't think that the government has enough evidence to prove anything. Certainly they can prove that John O'Keefe was in that front yard deceased. They could prove there was a blizzard. They could prove that Karen dropped him off. But I don't really think the government can prove much else. Like, there's really not enough evidence to show that she did it. And the evidence that does tend to show that it was her, the way it was come across, like, a few days later, not quite exactly the most reliable, we'll say.
The second trial is set to begin April 1st, with the second-degree murder charge still on the table, despite a federal appeal from her defense team. But what led up to a mistrial, and what's happened since? A lot. Let's take a look back at some of the first witnesses to take the stand.
I hit him. Oh my God, I hit him.
Experts say testimony of the first responders the morning O'Keefe was found outside of 34 Fairview Road in Canton is some of the most compelling evidence in the case. Reed is accused of backing into him with her SUV and leaving him to die during a snowstorm in 2022. Her attorneys claim she was framed and say the Boston police officer was beaten up at a party inside the Fairview Road home.
John never came into my house that night. He would have been welcomed, and the defendant would have been welcomed with open arms.
Reed's defense also claims the Albert's German Shepherd dog Chloe could be involved. But prosecution witnesses say no dog DNA was found on O'Keefe's clothing. A key defense witness, Dr. Marie Russell, will be back on the stand for Reed's second trial to testify about O'Keefe's injuries.
That are consistent with a large dog attack. There's a combination of both what I consider bite wounds and scratch wounds.
Another high-profile witness to testify in the trial, Jennifer McCabe. She helped Reed look for O'Keefe.
He said, I hit him, I hit him, I hit him.
A search on McCabe's phone will likely be a focus during Reed's second trial. The state's witnesses and the defense witnesses disagree on the time it happened.
I never made that search at 2:23. I never would have left John O'Keefe out in the cold to die because he was my friend that I loved.
A love triangle was also on full display between Reed and an ATF agent who was at the party that night.
The defendant kissed me.
And how did she kiss you?
Not like a friend. Defendant responded, "You're hot." I responded, "Are you serious or messing with me?"
Those weren't the only embarrassing text messages read to the jury.
Is there any indication
Bye,
that
guys.
Proctor is going to testify?
Yeah, Proctor's going to testify. Yep, they're going to call him.
From all accounts, he didn't do anything wrong. She's a whack job. No nude so far.
Lead investigator, Massachusetts State Trooper Michael Proctor, was fired in March after 3 days of trial board hearings. Documents say he was found guilty of unsatisfactory performance and drove his cruiser after drinking at dinner. 2 other state troopers were also disciplined in connection to the case after internal affairs investigation. Sergeant Yuri Buchanan had to forfeit 5 vacation days, while Detective Lieutenant Brian Tully had to give up 6. Reed and her defense have been critical of how the...
What kind of punishment is that? If you give up vacation days? What?
The investigation was handled by law enforcement because the homeowners...
Y'all. At the initial investigation, when they initially found John lying in the front yard, they collected the evidence in Dixie cups, which they put in a paper bag. I don't think you need to be a scientist to know that that is a terrible thing. It's ridiculous. Dixie cups?
His brother was on the Canton police force.
After 8 a.m., that crime scene was completely open.
Yes.
Unsecured.
Yes.
And available to anybody who wanted access to it.
Correct.
Didn't they just leave the crime scene open and available? Oh, what?
Police say taillight pieces were found outside the Canton home. Experts testified DNA belonging to O'Keefe was found on the defendant's taillight, and tiny pieces of plastic were found in his clothing. A federal investigation was launched.
That's ridiculous. That's ridiculous. The state's expert also said that her car was going at most 24 miles per hour. I do not think a 24-mile-per-hour collision will end someone's life. I just don't.
Into how police handled the case, but that's now over.
There is no longer any federal investigation into the investigation of John O'Keefe's death or any related matters.
So the investigation was done so poorly that the Fed started investigating the way the investigators did their investigation.
It is closed. It is over.
During that investigation, the feds hired 2 crash reconstruction experts from RICO. Both testified during Reed's first trial, but prosecutors say the defense misled the court about its relationship with the expert. Reed's attorneys say jurors have come forward saying they agreed to acquit her on the most serious charge, second-degree murder. A gag order is now in effect for attorneys on both sides, with fears the jury pool could be tainted.
Through the jury pools, find that there's nobody who hasn't heard of the case, but that you're going to try to do excellent jury selection to at least find people who have an open mind, who are not biased, who are ready to listen to the evidence.
Good luck with that.
That can be tough.
Motions continue to be filed.
That can be tough. That's an understatement.
With the second trial set to begin in April.
Okay, so her California lawyer, I forgot this guy's name, Jackson? He grew a beard. I'm not loving the beard. She still has this guy, which I don't remember his name, Yacopili. I don't know why, but for some reason, I find the balding Massachusetts guy to be attractive. I don't know why, but I'm oddly attracted to him.
It's going to be interesting because we've basically seen a preview because we saw the first trial.
Yep.
Including here in southern New England.
You see strangers who have come out and supported my sister week in, week out, and now for the first time here in Warwick. It's incredibly uplifting.
You can.
Okay, so.
Turn to 10 on air and on.
Highly recommend you check out that documentary on HBO. It was very, very, very interesting. And I just, again, I feel like this is more of a cold case. Like, I feel like they shouldn't be prosecuting this case. They should actually be doing a better investigation. You know, they never even searched the home. This guy's found on someone's lawn. He's allegedly at their party, and you don't go into the house where he went to the party. It's fucking weird. All right, I'm going to finish today with the YNW Melly update, okay? The W and the N and the M, they confuse me. Like, they're all kind of so, anyhow. So, YNW Melly. I've talked about his case before. I followed the first trial, not on the channel, but I followed it personally. The last time we talked about this case, I had told you that the government had subpoenaed Raven Liberty's iCloud file. Raven Liberty is one of Melly's defense attorneys. Now, I have so many issues with this. First, if you have Apple, get off that shit. Get off Apple. Okay, period. I don't care how convenient it is. I watched the trial of the guy in South Carolina, what's his name? Alex Murdaugh, or Alex Murdaugh if you're a normal person. The Apple data of him walking, the Apple data that Apple just handed to the government. They subpoenaed, Apple handed. That's what got that Alex Murdaugh. Now we have a lawyer. Her iCloud. Apple didn't call her. Apple didn't send her the subpoena for her to object. Apple sent all the shit to the government and then told her, by the way, I sent this to the government. Oh, and guess what? The government never disclosed to anyone that they had it all. The reason that the defense team learned that the government had gone into Raven Liberty's iCloud is because Apple sent her a letter and said, hey, we got a subpoena and we complied with it. Y'all switch to Google. Okay? Google actually has attorneys who are out there protecting the Constitution and protecting privacy rights, okay? That's all. I'm going to get off my Google Android versus Apple high horse. Android is a superior product, and your information is much safer with Google. But also, and finally, if you're an attorney watching this, do not use your personal email to do work. Have a designated work email and use that and that alone for client communications or communications that involve clients. Then, if your personal shit gets subpoenaed, you don't have to worry about your client's information being leaked to the government. Right now, as it stands, every single one of Raven Liberty's clients needs to be making motions to the government. I need to see what you got about my case from her cloud file. That's what I would do. If I was her, I would be making the government's life a living hell by contacting all of my clients and like, hey, we're writing this motion. Okay, so this is the latest motion. This was filed on the 24th at 5:50 p.m. by the defense. All right. Motion to compel discovery or alternative to reveal extent of state's intrusion on defendant's right to due process, client confidentiality, and attorney-client relationship. Here comes the defendant through the Florida rules. They want all property seized from Jamel Demons regarding Raven Liberty's accounts, copies of all materials in state possession obtained from the accounts, notice to defense of any and all documents received that have a bearing on attorney-client privilege, provide the protocol that was used to segregate information provided to the state under the search warrant for Liberty's Apple accounts, a list of witnesses who were involved in obtaining the search warrant, and any and all documents, search warrant affidavits, police reports, and findings in relation to the search warrant. All right. Here's the facts. On February 28, 19, state filed an indictment charging defendant with 2 counts of first-degree murder. March 5th, he did a plea of not guilty. April 6th, state filed notice to seek death penalty. They love the death penalty in Florida, you guys. They love the death penalty in Florida. If you live in Florida, get out. In October of 23, the state filed an information charging defendant with tampering with witness in a capital felony, directing activities of gang, solicitation to commit tampering, and conspiracy to commit tampering. On November 23rd, defendant entered a plea of not guilty. January 24th, 2024, the state filed its initial discovery responses to the tampering case. On December, he filed a motion for hearing with the potential conflict, setting forth that a member of the defense team was informed by Apple that her account information had been provided. On January 6th, defendant made an ore tennis motion to compel the state to provide an affidavit of search warrant. On January 7th, court modified its order and ordered the state to provide a copy of the search warrant. On February 7th, the court provided all defense counsel as well as defendant a copy of the unredacted search warrant. The unredacted search warrant revealed that every aspect of Miss Liberty's accounts and every bit of information contained therein were provided. Every aspect. That means every email, every step she takes with her little Apple Watch, every time she used Apple Pay, everything. It's all there. All right, during that year, the state never told Miss Liberty. I hate Florida, guys. Ugh. Only after the defendant brought this matter to the court's attention did the state even acknowledge the accounts had been seized. The state has contended that no other member of the defense team is under investigation. However, in a federal civil proceeding involving defendant, attorneys for the sheriff indicated the defense investigator has been subject to similar warrants. So first they say, oh yeah, there's no one else. But then they go to the Fed and they can't lie to the Fed. They got no problem lying to the state judge, right? Oh yeah, there's no one else. They get to the Fed, oh, well, we're going to tell the truth at the Fed. We did actually also subpoena the investigator through a warrant. The court granted defendant's motion to compel. The state was given 20 days. They have yet to provide any discovery subject to this order. What the fuck? If you're ordered to do something and you have 20 days to do it, you do it by close of business on the 20th day. What the? Okay. What is this word? Reticent. I guess, hesitant to involve itself. Okay, so although the court has been reticent to involve itself in the determination by the defendant as to whether he still would like to have Raven Liberty. See, because here's an issue. Raven Liberty, his defense attorney, is under this subpoena, under this investigation, right? And the investigation is closely related to her defendant. So her defense in that, if she gets charged with it, her defense might conflict with her client's. She might have to throw her client under the bus to defend herself. And that would not allow her to properly defend her client. And we talked about that when I went over the video where they're trying to get the judge to force the government to turn it over. He finally says turn it over, and now we're back to square one. They haven't turned it over. They not only raised an issue of conflict under the 6th Amendment of the U.S. Constitution, but attorney-client privilege, effective assistance of counsel, along with due process under the 5th Amendment. And 14th, by the way. Undersigned has been unable to find cases... I love this. Undersigned has been unable to find any cases in the state of Florida exactly on point to the situation herein. Rather, the actions by the state in this case appear to be such an anomaly of bad faith prosecution and government misconduct that the courts apparently have not had to rule on such egregiousness. I love that language. What is clear from both state case law and federal case law is that a hearing will need to be conducted by this court to determine the nature, extent, and prejudice to defendant both under the 5th and 6th Amendment. Okay. In State v. Kelly, the prosecution investigator went to defendant's house during the middle of the trial to ascertain information to use against the defendant at trial. Wow. The next morning at trial, the defense moved to dismiss the charges. The court conducted a hearing with both the prosecutor and investigator were examined and cross-examined. The case was dismissed due to the continuing prejudice of the defendant's right to due process. The idea of the requirement that the court get involved in determining whether the defendant's due process, client confidentiality, and effective assistance of counsel have been violated, requiring a hearing on the same is not new. So this judge has been refusing to hear anything. He's just like, no, it's up to the defendant, it's up to the defendant. And the attorneys for Melly are like, how can he make a decision if we don't know what they have? How can we make a decision if they haven't? He can't make a decision. And they found case law that said the judge needed to have a hearing about it, but the judge refused. And I definitely talked about that in a video. Okay, here we have U.S. v. Levi. The court conducted a hearing in which the government produced the testimony of several DEA agents and the prosecutor. The court required the government to produce the DEA case file. United States versus M. Neal. The court conducted an evidentiary hearing on the defendant's motion to dismiss due to governmental invasion of their attorney-client privilege. At the hearing, agents, Tate team prosecutors, and the prosecutors assigned to the case testified. Prior to the hearing, defense had the ability to review all of the material in the government's possession. U.S. versus Valencia Trujillo is another example of when due process, client confidentiality, and effective assistance of counsel, when impacted by a government search, warrants a hearing to determine the extent of the 5th and 6th Amendment violations. In this case, along with other testimony, the court heard testimony from 2 of the Tate team members. So the Tate team is supposed to be this neutral third party that works for, they're prosecutors, they work for the DA's office, but they're supposed to be neutral because they're not attached to the case. And they're supposed to review all of the documents and only give to the prosecutors those that are not tainted or those that would not violate attorney-client privilege. We see this Tate team thing come up in the Diddy trial also. In U.S. v. DeLuca, the district court held evidentiary hearings on DeLuca's motion to dismiss. The court heard testimony from AUSA Guard, ASU Stoddard, DeLuca, and the FBI computer analyst who initially segregated the data for the filter team. From these cases, it's clear that the court will have to conduct an evidentiary hearing to determine the extent of an intrusion on the defendant's 5th and 6th Amendment rights. However, in order to have a meaningful hearing, the defendant needs to be provided with all the material that's seized. Of course, in order to be able to determine whether this has been a violation of due process, effective assistance of counsel, and client confidentiality, all the witnesses, state attorneys, and agents or officers having any information must testify. Without a list of who these witnesses are, the defense will be unable to call them at the hearing. So this is why we need the list of witnesses. Okay. In U.S. v. Neal, the defense was able to review all the materials seized by the government upon demand. Government retained the same to defendants. Without being able to review materials seized from Liberty's account, the defendant will not be able to make such a demand. Defense has an affirmative duty, once it knows confidential communications are in the hand of the government, to raise privilege. So once the defense knows that the government has some kind of, or could have confidentiality, confidential documents, the defense they have a duty to bring up the privilege issue. Again, without seeing all the documents and evidence that were seized, how can a defendant make that specific demand? In Neal, the court said under Weatherford and Kelly, 4 factors are relevant to an alleged intrusion to attorney-client privilege. Whether the evidence should be used at trial was directly or indirectly from the government intrusion, whether the intrusion was intentional, whether the prosecution received otherwise confidential information about trial prep or defense strategy, and whether the privileged information was used or will be used to the substantial detriment of the defendants. It was indicated by the state a separate team of prosecutors or law enforcement agents reviewed the material seized from Liberty's account. As the court noted, it is clear that the government's affirmative decision to invoke these procedures constitutes a per se intentional intrusion. So anytime the government says, hey, we want to go do this, we need this subpoena, it is a per se intentional intrusion. Therefore, even prior to a hearing on this matter, the first 2 prongs of Kelly test, whether the evidence to be used at trial was obtained directly or indirectly, and whether it was intentional, have already been satisfied. Clearly, a hearing would determine the 3rd and 4th factors. Okay. I can't wait until that is heard by the judge. This was the case they were citing when they were begging the judge to force the government to turn the information over, when they were begging the judge to have a hearing, and the judge refused. So we'll see maybe if this motion inspires the judge. Maybe he'll go look up that case law and realize, like, he doesn't have a choice. He needs to have the hearing, and the government needs to turn that information over. It is very frightening that our government would be willing to take all this information and then not share it as required by the laws they wrote. Those are their rules. They wrote them. They need to follow them. Okay, guys. Thank you so much for being here today. Thank you for your likes, your subscribes, your thumbs up. Make sure in the chat you tell me where we should meet in NYC on May 6th. Make sure you take care of yourselves this week, and I will see you again next week. Thank you.